Greetings and salutations, my fellow servants. This is Vocational Science of Freedom Saturday Night Civics and 70 class. We'll be doing a little makeup class tonight. We will be continuing our reading of the book, The Great Taking. And I put the link to the book in the chat. And if you'd like to join the Vocational Science of Freedom Gilded server, you can do so by going to the Vocational Science of Freedom YouTube page, and it's right here, gilded.gg/VSOF. I do suggest to everyone that you download the application and then put in that to join. And we left off at chapter 4, I believe, which would have been the chapter on harmonization. So, chapter 4, harmonization. Those skilled at making the enemy move do so by creating a situation to which he must conform. They entice him with something he is certain to take, and with lures of ostensible profit, they await him in strength. Sun Tzu. What was the purpose of seemingly out-of-control financialization? The threat of financial collapse and the promise of continued financial profits have been used to herd the nations. An imperative has been created that certain secured creditors must be given legal certain claims to client assets globally, without exception, with the further assistance of near instantaneous cross-border mobility of legal control of such collateral. The global push for conformance to the U.S. model for achieving such legal certainty and mobility began in earnest more than 20 years ago in the aftermath of the dot-com bust. Financial instability and the threat of collateral shortages were used as justification. Deliberate efforts were sustained globally over many years. People were paid to do this, to betray the vital interests of their own people. It was done first in the U.S. and then demanded globally under the name of harmonization. Perhaps the emphasis should be on harm. And to stop and make a point here, this is what the attorney has been doing for centuries. And to make an analogy of the idea of what he just talked about the harmonization part, you can see it in what's called the Uniform Law Commission. And it's a group out of Chicago. And what they've been doing for about 150 years or a little longer is they've been altering state law so that all the states in the United States all operate more or less in the same way. And there's a lot of reasons, nefarious, most of them, as to why they'd be doing this. And the other aspect of this harmonization is in the implementation of the Uniform Commercial Code in all of the states as well. This is everything that they had to do prior to this great taking, prior to this global reset. And they had to get it done so that not only could the attorney move across state lines, but so that there wouldn't be any state law getting in their way for what they're about to do. So just be aware of that. And if you want to learn more about it, the best place to go learn would be the timeline class that I did on Odyssey. Well, I posted it on Odyssey because I couldn't post it on YouTube. So if you go to Odyssey, search for Vocational Science of Freedom, and then go to the bottom and the VSOF timeline class, I talk quite a bit about what the attorney has been doing for 150 years in America to alter our law and to specifically create what he just talked about, this idea of harmonization. Okay. So it's a good idea to go and learn what the attorney has been doing, not just here, but also in America as well through the states. Okay, to continue. The Hague Convention of the law applicable to certain rights in respect of securities held with an intermediary was drafted in 2002 and signed in 2006. It is an international multicultural treaty intended to remove, globally, legal uncertainties for cross-border securities transactions, which is exactly what I just stated with the Uniform Law Commission. The convention introduced a newly invented conflict of laws rule to be applied to security transactions, especially collateral transactions, namely the place of the relevant intermediary approach, or PRIMA. This was designed to avoid problematic national law, right, which might allow owners to recover their assets taken by a creditor as collateral by setting the place of law in the account agreements with intermediaries. One of the people most involved was James S. Rogers, perhaps a distant cousin of mine, who, according to his own biography, served as one of the United States delegates to the Hague Conference on Private International Law Project to negotiate and draft a convention on choice of law for securities holding through securities intermediaries, and as a member of drafting group for that convention. Interestingly, Rogers also notes that he had served as reporter, principal drafter, for the drafting committee to revise UCC Article 8, which established a new legal framework for the modern system of electronic book entry securities holdings through central depositories and their intermediaries. Now, as I just stated, they've been revising and setting up and rolling over everybody through the UCC. That's where they're hiding everything, if you will. The UCC is the global law merchant, if you will. And they had to establish the global law merchant before they could move forward with their total takeover and their total new world order, meaning the one world government, because all of the countries had to adopt this aspect of the UCC, meaning the global law merchant, so that no nation's laws would get in their way of what they're doing, which is stealing everything. So keep that in mind during this whole reading. All right, to continue. Very few people were involved in the drafting of the 1994 revisions to Article 8 and 9 of the UCC. A report by the Financial Markets Law Committee, a charity affiliated with the Bank of England, contains this illuminating quote. Professor Rogers, reporter to Article 8, 1994 Revision Drafting Committee, recalls how, quote, at the onset of the Article 8 revision, one could probably have counted on one hand, with a few fingers unused, the number of people among those appointed to the Article 8 Drafting Committee, or among the full membership of the sponsoring organizations that would ultimately have to approve the work of the Drafting Committee, who had any familiarity with either old 1978 version, Article 8, or the modern securities holding system. And to pause and make a point about that, you can see in those words that the attorney is losing more and more control every day. They don't know how this system was set up. They don't know their history. They are only told to go out and do these things. Usually they don't even know exactly why, to be part of the totality of the cabal. And the Khazarian mob just uses them as useful idiots as they do everybody else. They don't actually tell them what they're actually doing. They don't actually tell them what types of law, systems of law that they're operating under. They just think that everything's just whatever they say, and they just go along with it. So this is a very clear understanding of that they had, who had any familiarity with either the old 1978 version, Article 8, or the modern securities holding system. They just confessed that they had no idea what they were doing. To continue, if Professor Rogers was one finger, Professor Ergon Gutmann was the other, and the author of Modern Securities Transfers. He was the foremost expert on security transfers and secured transactions under Article 8 and 9 of the UCC. Professor Gutmann passed away in 2021. And so, descriptions of his activities are disappearing. But I have saved references to his work dating back to 2012. Professor Gutman had been involved in the revisions of various articles of the Uniform Commercial Code and as a member of U.S. Department of State working groups in the drafting of conventions relating to international commercial transactions. So, harmonization of this regime giving control globally to a select group of secured creditors was pushed from the highest level of the U.S. government. The Department of State was the first administrative arm of the U.S. executive branch, with Thomas Jefferson becoming the first Secretary of State in 1789. It is the foremost executive power globally. After years of effort, the Hague Securities Convention was signed only by the United States, Switzerland, and Mauritius. I don't even know that country. The European Union did not sign the convention due to the identification of problematic European law, which assured property rights to the owners of securities in some jurisdictions. Europe had the ancient legal principle of lex recipi, the law where the property is situated, and could not easily accept the workaround of place of the relevant intermediary approach, or prima, invented in the Hague Securities Convention. Right, because this is an aspect of common law. The law where the property is situated, this is an aspect of common law. And that's why, obviously, particularly England, but a lot of the other European nations have this aspect that if something is in a certain county, that's where it gets adjudicated as far as what it is. It still applies to land, but they were making sure that it didn't apply to their securities because they didn't want to get stuck, as I said before, under some other law or have some state get in their way as to what they wanted to do. To continue. However, the manifest objective of providing legal certainty to creditors was not in dispute and was clearly accepted by EU authorities, as evidenced by Directive 2002/47/EC of the European Parliament and the Council of 6 June 2002 on financial collateral arrangements. This document, which was published roughly contemporaneously with the drafting of the Hague Securities Convention, contains the following statements. In order to improve the legal certainty of financial collateral arrangements, member states should ensure that certain provisions of insolvency law do not apply to such arrangements. In particular, those that would inhibit the effective realization of financial collateral. The principle in Directive 89/26/EC, whereby the law applicable to book entry securities provided as collateral is the law of the jurisdiction where the relevant register, account, or centralized deposit system is located, should be extended in order to create legal certainty regarding the use of such securities held in a cross-border context and used as financial collateral under the scope of this directive. Notice this, where the relevant register, this is all about the registration of property. Everybody ends up registering their property, whether they know it or not. Mothers register their children with their birth certificate. You register your car with the state instead of taking the proper manufacturer certificate of origin home with you from the dealership. You register your guns. You register your microwave. You register your toaster. When you register something under Roman civil law, you give up ownership of it. The title is then split. You have legal title and you have equitable title. Legal title is the one that actually owns the thing. An equitable title, which is what they give you, allows you to use the thing, but you do not own it, which is why they can tell you that you have to put on your seatbelt, drive 55 miles an hour, have to have insurance on the thing that you don't own. To continue. The objective of legal certainty for creditors was to be pursued by other means. Where they could not easily change problematic local law in which investors had property rights to securities, they structured around it. This is what, and I'm going to say attorneys, investment bankers, and apparently government officials are paid to do. Now, this is what the Bar Association does. The Bar Association is the aspect of the law merchant globally. And that's what they're paid to do. Take from you. That's what an attorney is. To attorn means to take from one and give to another. A lawyer is actually someone who knows the law, like many of the people here. To continue. Euroclear is one of the two European International Central Security Depositories, ICSD, the other being Clearstream. The Brussels office of Morgan Guarantee Trust Company of New York, Morgan Guarantee, founded the Euroclear system in December of 1968. Morgan Guarantee being operating as JP Morgan in 1988. In 2004, the Deputy General Counsel of Euroclear, Diego Divas, sent a memorandum with, quote, preparatory information regarding European legal harmonization to DG Internal Market. Here are some excerpts. This note describes Euroclear's recommendations with regard to the legal barrier that should be addressed as property items by the legal working group that the Commission intends to set up as a follow-up of its communication on clearing and settlement in the European Union dated April 28, 2004. In particular, we identify issues that complicate and prevent the full implementation of major initiatives that the market is undertaking on platform consolidation and harmonization. Recommended. Removal or modification of requirements that do not recognize the multi-layer holding structure that is the norm in cross-border activity. Well, who made it the norm? Including recognition in the EU of the pooled holdings of registered assets. Again, there's that aspect of registration. Through a nominee structure and the different nature of legal and beneficial ownership in order to keep registered securities on a fungible basis at local level and protection of the rights of the nominee. Elimination or modification of requirements that directly or effectively require the maintenance of individual records or accounts per beneficial owner. Recommended. Eliminate impediments to free use of collateral cross-border. Right. If you've registered it, they're just going to do whatever they want to with it. And this aspect here, this difference between an order registered securities to protect the rights of the nominee compared to and different nature of legal and beneficial ownership. This aspect of legal and beneficial ownership, this is the aspect of the common law. So say your mother had stock in GM. She actually held the physical stock. Maybe she had it in a bank vault somewhere, right? Safe deposit box. Your mother passes away. You're the heir. You then own that stock. You hold it. You have it in your hand. You haven't registered it. It's not in book form. You actually have it in your hand. That's actual ownership. But once you register it, and it's a book entry, then they, being basically the guardians and administrators, if you will, of the registered property, they can do whatever they want to with it. So, to continue, Diego Divos went on to be appointed General Counsel of the Bank for International Settlements, IBS, in 2009. As noted in the preceding chapter of April of 2004, the European Commission Internal Markets and Services Director General proposed setting up a, quote, group of legal experts as a specific exercise intended to address problems of legal uncertainty identified in the context of considering the way forward for clearing and settlement in the European Union, close quote. That's just a fancy way of saying attorneys are getting together to kvetch and steal from you once again. It took 10 years of convincing, but in 2014, the way forward was made certain with the Central Securities Depository Regulation, CSDR. I had arranged to speak at a hedge fund conference in Zurich in January of 2014 to warn the quote-unquote professionals about the undermining of property rights to securities and of the implications. I thought perhaps the tide could be turned in Europe. Believe it or not, this was in large part my purpose in moving to Europe. Prior to the conference, I had sent personal emails with the outline of my points to all of the attendees. While I was speaking, by the bright light of the projection screen, I could see that the eyes of the people in the room were as wide as saucers. When I finished, there was complete silence. In the coffee break that followed, I asked people what they had thought about what I had said. I asked if they understood what I was explaining. One person merely replied, "Oh, yes." I asked him what he would do about it. He simply said, "Nothing." I asked him why he would do nothing. His reply was, "My clients don't care about this." I said, "They don't care about it because they don't know about it." 6 months later, the Central Securities Depository Regulation, CSDR, was implemented by the EU Directive number 909/2014. A Central Security Depository, CSD, operates a book entry system for electronic settlement of trades and maintains a record of quote-unquote ownership. An International Central Security Depository, ICSD, is linked to national CSDs, and it handles securities lending and collateral management, as noted by the European Securities and Markets Authority. CSDR plays a pivotal role in post-trade harmonization efforts in Europe, as it enhances the legal and operational conditions for cross-border settlement in the EU. And thus, the desired goal of cross-border mobility of collateral has been achieved. How is it engineered? CSDR provides for links between CSDs. National CSDs, which hold the record of ownership, are linked to the international central security depositories. The transfer of legal title to customer collateral from the national CSD to the ICSD and the use of customer collateral are thus enabled. The customer has quote-unquote ownership in the book entry system of the national CSD, while the collateral is held in pooled form at the ICSD level. Now, to stop and make a point here, this is exactly what they did. What he's describing here is exactly what the governors did when they committed treason against their own people in their states in 1933, when they had the governors' meeting in D.C. And all the governors got together in D.C. in 1933 and pledged to Roosevelt all of the registered property on the state level. Why? For loans from the cartel known as the Federal Reserve System, because the United States corporation was bankrupt. And that's what happened in 33. Along with it was the gold heist on May 1st of 1933, which is the Luciferian high holiday, by the way. So all of this has been prepped for a very long time. This could not be going on right now if the state governors had not done what they did in 33. And none of this would be going on right now also if all of you would stop registering your property. If you stay out of the Roman civil law system, which is all this aspect of registry and splitting the title, you'd actually own what you have. But there's a problem with that. You see, under 1 United States Code, subsection 8, in the definition section, if you go read the definition of person, you will find that a person is an infant. All the United States Code deals with is the administration of infants' estates, because you have never come back and claimed your estate from your mother abandoning you at the foundling hospital. And a foundling is a child of unknown parentage. Found. That's a foundling. That's what you are, until you come forward and claim your title and claim your estate, which used to be done in English jurisprudence in a place called the Court of Wards and Liveries, which then was changed in the Court of Wards, which was run by the East India Trading Company. Not a joke. Go look it up. So they've been doing this for a very, very long time. But they want to do it globally because it worked so well for them, particularly during the English Empire, which that was a kickstart from what they were doing in 1666, which was the Cestui Que Act. But I digress. Just a little back history. All right, back to it. We will see how that has worked in looking specifically at Euroclear and developments in Finland and Sweden. Once upon a time, Finland and Sweden had legal systems and national registries of securities ownership, which assured owners that their securities could not be used as collateral without express agreement. Exactly. It had been possible to own and hold Swedish government bonds, for example, with absolute certainty that they could not be lost in an insolvency of a custodian. In 2006, the Legal Certainty Group identified Sweden and Finland as having problematic law. Right, you think? In 2008, Euroclear was allowed to acquire 100% of Nordic Central Security Depository, which owned the central security depositories of both Finland and Sweden. Suman Aroph, I'm not even going to try and pronounce that name, and VPC AB, respectively. These are now local CSDs linked to Euroclear Bank, which operates as an ICSD under Belgian law. CSDR requires an account provider to publicly disclose the levels of protection and cross-associated with the different levels of segregation of securities accounts at the central securities depositories. Right, and this is an aspect of what that means, more or less, is that they're supposed to keep all funds separate. They're not supposed to be cross-mingling funds, but that's exactly what Fidelity does with everybody's Fidelity bonds that are attached to their birth certificate. They commingle them in tranches of either 8 or 12. So even if you were to find the actual security, the actual Fidelity bond that's connected to your birth certificate, it's going to be commingled with either 8 or 12 others. So it makes it very, very difficult for someone who actually has lawful claim to have proper accounting as to what they are actually owed. And this is exactly what the attorney wants. They want everything commingled, and they never want anybody to ever be able to come back and actually claim what's theirs and say, no, that's mine, and I have a right to it. That's not in their interest. To continue, Skalin, Neveska, and Skildebanken SEB makes such a disclosure with respect to central securities depositories in Sweden, Denmark, Finland, Norway, Euroclear Bank, and Clearstream Banking SA. Here are the shocking key passages from that disclosure. The unlikely event of a shortfall of securities, the client in question will not be able to claim a right of separation. Can't get more clear than that. Will not be able to claim a right of separation, but will likely be considered as an unsecured creditor without priority to the assets of the bankruptcy estate. Notice that word? Estate. Everything that they're doing is about an estate. Your estate, my estate, the estates of millions of people in each country. This is what they're doing. It's about the administration of estates. And that's why they're administering all of our estates as infants. They're holding everything that is actually ours because we never come of full age and claim it. Okay? But just remember that this is all about estates and title. The case of securities held at Euroclear Bank, SAVN, Belgian law, the Royal Decree number 62, applies provisions following the principle sync that all securities deposited by Euroclear Bank participants, i.e. SEB, with Euroclear Bank, are deposited on fungible basis. By virtue of the Royal Decree, Euroclear Bank participants have been given by law a co-ownership right of an intangible nature on a pool of book entry securities of the same category held by Euroclear Bank on behalf of all Euroclear Bank participants having deposited securities of the same category, right? So they just spread your ownership out throughout every single tranche, and they're just commingling everything. The said decree provides for a loss sharing provision for the underlying clients of a Euroclear Bank participant in case such Euroclear Bank participant goes into default. Furthermore, Belgian law gives the National Bank of Belgium privilege over Euroclear Bank, their own proprietary securities to cover, e.g., a situation where securities that are held by Euroclear Bank with any depository on behalf of its participants are not enough to cover the actual holdings of such securities by the participants. That's an extremely long-winded way of saying that if we go and start playing in our open air casinos called stock markets, and we keep creating more and more derivatives. And if those derivatives come up and we don't have enough to pay it, we can just jump across a line here and say that, oh, these other people's securities can now be used, right? On behalf, just in case on behalf of its participants are not enough to cover the actual holdings of such securities by the participants. That's all it is. It's a long-winded way of saying, we'll grab your shit wherever it is. We don't care. That's what they just said. To continue. Thus, over a period of 6 years, property rights to securities in Sweden and Finland were deliberately subverted. These countries went from having the strongest property rights to securities to having no property rights to securities beyond an artificial appearance of ownership. In 2014, coincidence with the EU directive on central securities depositories, shocking changes were made to Swedish law. Very few know about this, other than the people who did it. I tracked this down through a cryptic reference in a Euroclear document. General terms and conditions account operations and clearing. Buried in there, on page 38, is the following clue. 14.2, prevailing law relating to the disposal of VPC accounts and financial instruments registered, there's that word again, in a VPC account. The real consequence of disposals relating to VPC accounts and financial instruments registered in VPC accounts are governed by the provisions in Chapter 6 of LKF. This quote refers to Sweden's law on central security depositories and accounting for financial instruments. Chapter 6 of this law is titled, in translation, quote, legal effect of registration, presumption of ownership. Buried at the bottom of this chapter is found the further direction. Special provisions on pledging of financial instruments are found in the Act 1991:980 on trading in financial instruments. Within Act 1991:980, Chapter 3 is titled Disposal of Financial Instruments Belonging to Someone Else. Now we're getting warm. This first paragraph states that, quote, the intended disposal must be specified carefully. That seems like a good thing, but it goes on to state the following. The first paragraph does not apply if the company's counterparty or the parties to an agreement in which the company participants is another company that is under the supervision of the Financial Supervisory Authority or a foreign company with the EEA that is allowed to run comparable activities in its home country and that is under the reassuring supervision of an authority or other competent body. This gives the local CSD legal authority and broad latitude to pass legal control of customers' assets as collateral to the ICSD without the knowledge or approval of the account holder. The implementation of this is now so that a Swedish citizen cannot hold Swedish government bonds in Sweden as property without exposure to insolvency of the account provider. The local CSD or the ICSD, the securities of Swedish citizens are certainly pooled with securities being used as collateral elsewhere. I came to Sweden in 2009 in order to be able to hold Swedish government bonds in Sweden with property rights. I was able to do that using a VP Konto account at Handelsbanken. However, following the legal changes made in 2014, Handelsbanken completely discontinued the VP Kono structure and offered clients only custody accounts. SEB also discontinued its long-standing VP Kono structure, which has assured direct ownership of specific securities, but then introduced something they called Service VP Kono, which is held with the local CSD Euroclear Sweden. I called into SEB about this and was told that a VP Kono specialist would call me. When I received the call, I asked two simple questions. 1. Are securities held in a Service VP Kono specifically identified under the name of the account holder? And 2, can the securities held in a Service VP Kono be revindicated in the event of the failure of SEB or of Euroclear? The VP Kono specialist put me on hold for a long time while he investigated my questions. When he came back, the answer was simply that while there might be a small risk of failure of Euroclear, the account was insured for 250,000, I think that's crowns. He confirmed that holding of securities at Euroclear was the change made with the new service VP Kono structure, and he confirmed that there is a risk of loss of securities with the new structure. He seemed shocked himself to have learned this. In 2011, a friend who had been a state in Swedish government arranged for me to meet with the minister and the state security for financial markets. I was so moved when I received the email informing me of this. Tears came to my eyes. It gave me hope that in Sweden, it might be possible to make a difference, and thus to turn the tide somewhere. I am forever grateful to them for that meeting. Such a thing would never be allowed in the land of my birth. They heard me out about the implications of conforming to the U.S. model and did not disagree. They said it might be possible to avoid this if the Germans would stand against it, the implication being that the little Sweden could not do it alone. The juggernaut rolled on. We are all in its path. Chapter 5, Collateral Management. And this is where we'll come back to next week. And just to check chat. Oh, thank you, Knucklehead, for posting that. This is literally the poster under executive order of the president when they did the gold heist. This is what was posted in every single post office. Under executive order of the president issued April 5th, 1933, all persons are required persons. Remember what I said about persons? Persons are infants. That doesn't say people, that says persons. And yes, in law, sometimes you will actually see the word people, but you're only going to see it in public law. You'll never see it in statute, act, ordinance, or code. It'll only be in public law. Okay. All persons, all infants, are required to deliver on or before May 1st, 1933, all gold coin, gold bullion, and gold certificates now owned by them to a Federal Reserve Bank, branch, or agency, to any member of the Federal Reserve System. And the executive order is a little bit small, but you guys can obviously go look it up and read the totality of it if you wish to. But this, at the bottom, they said criminal penalties for violation of executive order, $10,000 fine or 10 years imprisonment, or both, as provided in Section 9 of the order. As provided in what? Section 9 of the order? So Roosevelt decided to create an executive order of which he created penalties. So tell me exactly how the executive branch can all of a sudden decide to write law. I'm pretty sure that's something specific to only the legislative branch. But anyway, you can see how this has been going on for a very, very long time. And what we're coming to is their totality of the end of it. And that's their great reset. So, does anybody else have any questions or comments about what we've been reading tonight?
We're still under martial law, and the executives or the president's order be valid.
Okay, if you want to actually take it from the standpoint that, yes, we're still under martial law from the Civil War, does the executive have a capacity to make executive orders as more or less a commander-in-chief under martial law? In a sense, yes. However, martial law of an occupier, and that's exactly what the United States Federal Corporation is to the de jure states. They're basically an occupier. If you read the DoD Law of War Manual, there's very specific things they can and they cannot do. And fundamentally altering the law of the occupied territory is not one of them. So in a sense, you're correct, but at the same time, it still went too far.
So how do we know what laws would be valid in martial law and what laws?
It's laid out in the DoD War Manual. It would be several days to go through that entire book and show you where it is. A lot of them have to deal with the, as I said, in a very generic sense, the fundamental law of the state of which the occupier is taking over or is occupying. And can't remember the exact verbiage in the DoD Law of War, and that's not the only place it is either. There's another few places. The military itself has some other documents regarding martial law, which I think I have in the Vocational Science of Freedom members online library. Check under military. I'll check after class and see if it's there, because I think there's a whole entire military manual on martial law as to what can be done and what cannot be done. But those would be the first two places that I would go look to answer that question. But I'm sorry, I can't answer it right off the top of my head. Other than, like I said, that generic aspect of the fundamental changing of the law, which of course is the aspect of completely eviscerating the common law of the people. And that's what they've been trying to do forever in America. That's what they hate the most, is us being self-governing, sovereign people, where we convene 25-member grand juries, we investigate what we feel like, we indict who we feel we need to indict, and then we prosecute in 12-member petite juries in courts of record, whether that be for treason, common law theft, both of which carry the penalty of death. That's not something that they like very much, because banking as a whole is a profession of theft. So it doesn't really bode well for them if the law of the nations, particularly the sovereign nations, and we the people in America, say no. And as I read tonight, that's exactly what they've been doing. But they had to do it here first in the States under the Uniform Law Commission. Once anything's registered, they're considered to having the legal title. Because under Roman civil law, the title is always split between legal and equitable. Under common law, there is no splitting of title. You either hold something in allodium or you don't. And the holder of an allodium, whatever it may be, that if you're the absolute owner, I guess is the correct term under common law. If you're the absolute owner of something under common law, anybody who takes it, uses it, abuses it, destroys it, or mismanages it is automatically subject to a tort, and even possibly the filing of a suit for common law theft, which again, first offense under common law for thievery is death.
All right, so a follow-up question: if they hold legal title, illegal title, how can we actually gain legal title?
You have to unregister it, or you have to claim your estate. Because if one does not claim their estate from being an infant, meaning of coming of full age and claiming your estate, and this is stated in the Magna Carta in Articles 3, 4, and 5 as well, as it is also stated in the Court of Wards and Liveries procedure, which you can look up online. And in a sense, the other presumption, aside from infancy, is death, which they put into the system in 1666 with the Cestui Que Vie Act. They presumed everybody dead to the law. And until you have been found to be living in an action, everything that you have, your entire estate, is administered. As it is, even if you had been found to be living in an action, but you were still considered to be an infant, you still wouldn't be able to hold title. You still would have your estate administered by someone else. And that's why all the judges and black-robed priests out here in all these private for-profit courts are all special administrators under the Uniform Probate Code.
All right, so even though we may have done our status document work, it still is going to end up in a process where we can basically go to probate and actually make this a matter of action for public.
It can be done that way. I have not determined at the moment that a whole entire process going through probate would be required. Technically, we do the process in the VSOF status doc set anyway. It's the coroner proof of life and proof of age inquisition, which is signed by a petite jury, and that's it. Because under the common law, once the jury decides something, it's over. It's res judicata. It's done. And so basically, from the standpoint of all who have done their status docs, then what we need to do is 25 of us need to get together, put together a banker's box of all of our status docs, and then send that off to the DTCC before they totally run away with everything and stick it God knows where, and make the claim. Because you have to make the claim to the guardian. And under the DC code, when I was looking for who are the guardians of the abandoned infants' estates, I always thought and presumed that it was the United States Federal Corporation, but it's not. It turns out that it's trust companies, which makes perfect sense. when you see what they're doing and going through this book. So we have to come together as 25, and I want to do it as a grand jury, come together as 25 and say, hey, well, actually, there's two ways to do it. We could do it as a grand jury. The other way to do it is that 25 of us come together and we create our own trust company. And then we approach the DTCC as a trust company and say, all of these estates that you hold all of these securities for, every single one of them now has to be transferred to our trust company because the heirs have been found to be living and have made demand of claim upon said, and we are now going to be the custodians, even though we are the ones that own our own estates. Obviously, that might be, and I'm putting that like in air quotes, might be the requirement of what we have to do. Hopefully we don't have to go that far, because technically, if you've come of full age, you've been found to be living, you make the claim, it says in the Magna Carta, in Articles 3, 4, and 5, that the administrator must immediately give the estate to the heir. So it's written by common law that they must do it immediately. Now, I've had some pretty interesting back and forth before in these inferior courts with certain special administrators who got very scared of certain things that I said and were looking to run out their little quick side exit door as fast as they could to go and take themselves off of the case because the heir had shown up. Now, are they going to be the ones stuck with it? Yeah. Are they going to be even have the capacity to give everything, meaning the stupid little black robe priests of El that are sitting on the bench? No. We need to go to DTCC. We need to go to Fidelity. We need to go to all these other trust companies that are listed in this document and others and make proper claim. They have claim forms. I have not looked at them in a long time. Many, many years ago, over a decade ago, there was a time where I went through all the DTCC internal documents. It took me almost half a year, but I got pretty familiar with them, and they have claim forms. And I wasn't prepared to do the claim back then because I hadn't finished the doc set. Well, now I finished the doc set, and a lot of people are ready to do the claim. So that's technically the next step that we need to do, is making that claim.
It's possible we can go ahead and research that to get the ball rolling or something like that.
Yeah, there's two committees. We have a DTCC research committee, so we could do it there, at least the DTCC stuff. That's committee 7. And then we also have committee 3 is settle our estates. So there's going to be cross information in the estate forum for the committee 3 and committee 7 regarding what we're going to have to do making the claim. So yeah, the committees are already there. We just need somebody to take as chairman and then start running monthly meetings. And I will definitely help with anybody decides to be chair. I will definitely help with the monthly meetings. I don't have the time to chair a committee at the moment, but anybody's welcome to do so. So, and then there's a different IRS committee too, if we got to, deal with them on a certain, from some other certain aspect. I don't think the IRS doesn't really hold anything. What the IRS is a glorified accounting firm for every single abandoned infant estate. That's basically what the IRS is. So the master file might be interesting. So we might be able to get the master file from the IRS, put that in with our request to the DTCC, and then go from there. That, I think, would probably be the most logical thing to do. So, okay, if there's nothing else from anybody else, doesn't look like it. I'd just like to also add that everybody should also read, along with this document, The Law by Frederick Bastiat, and I read the beginning excerpt from it last week, so I won't rehash that again. But it's a very short book, and it goes right along with everything of what's in The Great Taking regarding the movement, the bastardization, the manipulation, and the destruction of the law by the attorney. So with that, I hope everyone had a wonderful time tonight, and I hope you learned something. I will be continuing this reading until I get done with it on the Vocational Science of Freedom Saturday Night Civics and Sovereignty classes. And we will have the Wednesday night roundtable coming up this week as well. So until that time, stay safe and stay sovereign.